Welcome to the First District Court of Appeals video conference oral argument session for Wilson v. State, case 19-3764. Counsel for appellant, Mr. Ufferman, you may proceed when you're ready.
Thank you, Your Honor. Good afternoon. May it please the court. Michael Ufferman on behalf of the appellant, Ortavious Wilson. I'd like to reserve 5 minutes of my time for rebuttal. I'm hoping to focus my time this afternoon on the first claim raised in the briefs, and then if I have time left, I'll also briefly address the newly discovered evidence claim, and of course I'll answer any questions that the court has regarding any of the claims. But let me begin with the first claim, and that is whether counsel was ineffective for failing to object when the prosecutor gave an oral interpretation of the recording in this case. And I think there's 3 parts to this claim. First, were the prosecutor's actions objectionable? Second, was defense counsel's action in failing to object strategic? And third, was Mr. Wilson prejudiced by defense counsel's ineffectiveness? And I'll go ahead and just take them in that order. Both in the trial court order below and in the answer brief, the trial court and the state are arguing that what the prosecutor did in this case was perfectly permissible. It was a fair comment on the evidence. And in response to that, I've relied upon the Wilson case from the 3rd DCA. And in Wilson, we know the 3rd DCA said that the law in Florida is clear. When partially inaudible or completely inaudible recording is introduced or played during a trial, it's only appropriate for a witness to give an oral interpretation if either A, the witness is someone who has personal knowledge of the contents of the recording, or B, the witness is an expert witness who's skilled in interpreting inaudible tape recordings. Neither of those.
Let me, and thank you for setting out a nice outline for us. I do have some questions about that outline, but before we get into the specifics of your argument, this video, this in-car video, was admitted into evidence, correct?
Yes, correct.
And that's not a question on appeal about whether or not that should have happened.
Correct. The claim is not whether defense counsel was ineffective for failing to object to whether it could be admitted. There's an argument that defense counsel perhaps could have. I think the standard for admitting that partially inaudible recording would have been much lower for the state. I think part of it was audible. Parts could be transcribed by the court reporter. So I'm not sure there would have been a valid objection to keep it out completely. I think the issue, as specifically outlined by the 3rd DCA in Wilson, is when that occurs, when a partially inaudible recording is played during the trial, can a witness give an oral interpretation? And I think
and thank you for saying witness, Mr. Offerman, because Wilson talks about a witness. Here Correct. We have a prosecutor. Isn't that a different analysis point, algorithm?
I think the same analysis would apply. So if the state in this case didn't have a witness who had personal knowledge, and there's only 2 people who would have had personal knowledge, Mr. Grimsley and Mr. Wilson. The state could have questioned my client when they cross-examined him to try to establish that, but that did not occur. And the state did not have an expert to interpret that recording. So why, if a witness could not do that during the trial, should a prosecutor be able to do that during closing argument? And if that were permitted, then wouldn't the rule in Wilson really be meaningless? Because a prosecutor could go out and, let's say, get an expert and say, hey, this is what I think is on that recording. You're an expert in interpreting inaudible tape recordings. Do you agree with my interpretation? The expert says no, and the prosecutor says, well, forget it. I don't need to use an expert then. I'll just give my own oral interpretation during closing argument.
But is not the difference. One is evidence. A witness provides evidence. A prosecutor or defense attorney makes argument, and repeatedly, looking through this record, the prosecutor said that nothing I'm telling you, ladies and gentlemen of the jury, is evidence. Isn't that an important difference? And plus the jury instruction to the jury.
You know, and I think, Your Honor, you and I have had this discussion in another case involving if the jury is instructed that what a prosecutor says is not an evidence, doesn't that cure any error or make it so there is no error? I submit, of course, there are numerous cases under Florida law where a prosecutor says something inappropriate, that same instruction is given, and Florida courts have granted relief because you can't unring that bell. So in this situation, I disagree. If a witness has not given the oral interpretation, it's not a fair comment on the evidence for a prosecutor to then go ahead and give his interpretation of what that tape means. It would be completely fair to say, look, there's been a recording that's been introduced. It's hard to hear. You go back and listen to that and you give your own interpretation to that. it would not be appropriate, since no witness did it during the trial, nor would they have been permitted to do it during the trial, to then go and say, actually, I have my own interpretation. So yes, you go ahead and listen to it, but here's what is said. And there's 15 pages of oral argument where the prosecutor plays a snippet. Usually the court reporter simply says no intelligible portions to be reported, but then the prosecutor goes on for paragraphs saying, this is what you just heard. So the most extreme example is what I've cited in my brief on page 505. This Wilson says, when I was in that car, man, I said, put your hands up. Don't reach for nothing, man. When I was at that car, I said, put your hands up. That was extremely damaging interpretation for my client, because maybe the jury didn't hear that. It would be up to the jury to decide what they did or did not hear. No witness in this case could have gotten on the stand and said that's what my client said, unless it was Mr. Grimsley, who the state didn't call as a witness.
Mr. Offerman, I noticed, unless I misread it, that the defense attorney, I think you noted in your brief, moved for a new trial on this basis?
Yes, and so that kind of goes to where defense counsel's actions strategic. The state points to one answer.
My question is more procedural. Okay. So the defense counsel moved for a new trial on the basis that the prosecutorial argument was improper.
Correct.
I took it from the brief.
Yes.
So she wasn't ineffective in that sense. Well, the new trial motion was obviously denied. Can you talk just briefly? So. I'm sorry?
Correctly so, because it was untimely.
So you don't think the trial court made a legal error in denying the motion for a new trial?
I think at that point, the trial court could say, based on this record, the defense attorney specifically agreed to allowing oral interpretations. I'm not going to allow you after the fact. That's a classic gotcha scenario that this court cites to in numerous cases, that defense counsel can't sit by silently, or even worse, agree to the procedure that's being utilized and then turn around.
Did the trial court, and I'm sorry, I don't know this off the top of my head, did the trial court express a rationale for denying the new trial?
I think it was just denied. I'm not aware of a rationale that was given specifically. I can carry it on further, though. The issue was raised on direct appeal, and the state argued in its direct appeal answer brief that the error, the alleged error, was not preserved because there was no timely objection. And again, it's even worse than no timely objection. It was actually agreed to by defense counsel. So defense counsel, again, during the evidentiary hearing, was asked about this, and she said over and over again, I was not familiar with the law. And then for one question on cross-examination, she was asked, wasn't it strategic for you to agree at that time, based on what you knew then, to allow both you and the prosecutor to give an oral interpretation? And she answers yes. But if you read her testimony in context, she then says, but I didn't know at that time that the law said an oral interpretation could not be given. So then as soon as the verdict came back, I went and researched it, and she does timely file a motion for new trial raising Wilson and saying it was improper for the prosecutor to do this. But again, at that point, she'd already agreed to it.
So when she said it was strategic, was that because she thought that her oral interpretations were favorable to the defendant?
You said, so she was clear about that, and I'm glad you asked that, Your Honor. I think she just answered a leading question from the prosecutor. Strategy didn't come out of her mouth.
No, I understand that, and I appreciate your argument there. And but
was it strategic? And she said yes.
No, I'm asking, did she, in closing argument, and argue for a favorable oral interpretation of inaudible testimony?
She tried to give her own, but I would submit that there's nothing she could say that was going to overcome a prosecutor telling the jury that, listen, he testified at trial. He's giving you a version of events. His version of events is completely refuted.
But doesn't that go to Judge Jay's question? It's just two advocates slugging it out, saying, here's what I think the inaudible tape, here's what I think a logical hearing of the tape means. The opponent says, here's what I think. They agreed to it.
That's why she went further. She was very clear during the evidentiary hearing. She didn't know at the time, but had she known, she would have objected and not allowed either party to give an oral interpretation. And then she was specifically asked during the evidentiary hearing, what was better, you and the prosecutor giving an oral interpretation, or neither of you giving any interpretation? And she was very clear, without question, if I could have kept out both interpretations, I would.
But that's 20/20 hindsight.
Well, no, but
hold on a second. Whether she says it's strategy or not, strategic or not, if you're in the heat of battle, so to speak, and you think I can put a spin on this tape that is going to be very helpful, because part of the tape's coming in. I can't keep it out. And lo and behold, maybe it doesn't turn out to be helpful and you receive an adverse jury verdict. Doesn't that seem like that would be kind of the height of gamesmanship to then be able to assert an ineffectiveness claim?
But for this, Your Honor, and this is the key, and I've cited to the 5th DCA's case and Butler, where they say, and they cite federal case law, it is well established in a number of contexts that a tactical or strategic decision is unreasonable if it is based on a failure to understand the law. That's the key. If she would have said at the hearing, I knew full well that Wilson says you shouldn't give an oral interpretation, and I didn't want to argue Wilson because I thought it was better for us to be able to give our own oral interpretation and then we'll fight it out, that would be one thing. But she candidly admitted she had no idea what the law was. And more importantly,
my question maybe goes more to prejudice. If she's giving her own interpretation of the inaudible testimony and it's favorable to her client, and she thinks, forget whether or not she could have blocked it all out, perhaps that would have been more strategic, perhaps it would have been more favorable, but logically it doesn't mean there's prejudice if during the trial, a counsel thinks, hey, I can work with this to my advantage, right? I mean, it goes to prejudice. Maybe you could, and I'll stop there, but maybe you could answer that.
I did, well, and I say I'm into my rebuttal time, but I do want to answer this. I think it's very important. I think it actually does go to strategy. I think she didn't know at the time that she could object based on the law, and she was very clear about that. And then to specifically answer your question, she was asked, would it have been better for there have been no oral interpretation from either party, or did you gain any benefit by giving your own oral interpretation? And her answer was crystal clear. It was extremely damaging for the prosecutor to give an oral interpretation in this case.
But that's an objective inquiry, right?
It is an objective inquiry, but again, she didn't know the law. So
I know, but I understand that. But this is not a hostile question or a trick question. Isn't our evaluation of whether her interpretation of the inaudible testimony, whether that was prejudicial, that requires us to review the entire record and make an objective decision?
Yes, and again, I think, and just quickly, when I only want to spend 30 seconds on this, there's several reasons.
Maybe I could ask the chief to indulge us and give you a couple minutes extra.
Well, I appreciate that. I think there's several reasons why my client was prejudiced. Number one, this is an extremely close case. It was a he said case. The alleged victim is the one that actually shot someone in this case. His theory was it was self-defense. My client's theory was I wasn't even there and he shot my friend. So it came down to, do you believe the co-defendant or not? And yet, and defense counsel was very clear at the evidence you're hearing, the strongest piece of evidence the state had was the recording. And what made it so much stronger was the fact that the prosecutor was able to give his oral interpretation of this and say that in essence, my client confessed to being there at the time of the shooting, which would refute his trial testimony. I think the defense counsel's motion for new trial sets out numerous reasons why the alleged victim was not a believable witness. There was things about his story that were inconsistent. Again, the prosecutor spent 15 pages on his closing argument going through his oral interpretation of this. If anything, or to top it all off, during the evidence you're hearing, defense counsel said that after the trial, she actually spoke to someone in the audience and said, what made the case go against us? And the person said, the strongest piece of evidence the state had, this case changed when the prosecutor began giving his oral interpretation of the recording during closing arguments. So none of that was refuted during the evidence you're hearing. And
we're not going to rely on people from the audience, right?
Well, but these are tough. We can't call the jurors back in. I would love in my 3.850 hearings, I'm not permitted to do this, but if I could call the 6 or 12 jurors back in and say, had you been presented this or not been presented this, would this have changed your mind?
But for prejudice, don't you just look at the overall evidence?
You do, and so not only was this a close case, the other thing I would point to is the co-defendant in this case was tried under the same facts and was acquitted. So that's how close of a case this was. So when it comes to prejudice, I submit that my client has a very strong argument that there's a reasonable probability that but for the prosecutor getting up for the focus for the majority of his closing argument and saying, don't believe the defendant's testimony because his testimony is refuted by my interpretation of what he's saying on that recording, that the result would have been different had the prosecutor not done that. I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Ufferman. Mr. Corzine, if you'll add 3 minutes to Mr. Ufferman's rebuttal time and of course extend Mr. Shippey's time as well.
Thank you, Chief.
Thank you. Good afternoon. My name is Darren Shippey. I represent the state of Florida in this matter. Let me respond to some of the things that counsel brought up that might bring this into clear focus. The image that comes to mind when you view what the defense wants to do with the Wilson case is a person with a size 10 foot who desperately sees a size 4 shoe that's very attractive to that person, and they want their foot to fit inside of it, but it doesn't. And that's the situation with the Wilson case, as has already been brought out by, I think it was Judge Jay, that it is a case that talks about an evidentiary principle. It has nothing to do with closing arguments, notwithstanding defense counsel's fervent attempt to make
counsel. If the evidence, if the commentary on the inaudible tape was not in evidence, or the inaudible portion's not in evidence, then the prosecutor talking about it is improper comment based on arguing evidence not admitted before the jury, right?
Well, I have to respectfully disagree with you. The fact that something is not transcribed by a court reporter does not mean that it is not in evidence. I have listened to that in-car video. I've taken my own notes of that in-car video. If you listen to that in-car video, you're going to hear a lot more than what gets transcribed. And frankly, it's very condemning to the defense. So the evidence in the case is, in fact, the recording. It is not a transcription of the recording whatsoever. So I respectfully have to disagree with you, Judge Thomas. The other thing that struck me in talking about that, which I think is a good follow-up, is if we had an optical illusion that was introduced into evidence and nobody testified as to what the optical illusion was, then does that preclude me as a prosecutor from arguing what I believe it to be? And does it preclude defense counsel from arguing what it might otherwise be? So an optical illusion is also a good analogy in how to view this situation. The defense actually made quite a big deal. That's its interpretation, which factors into the reasonableness of her strategy decision. She made a decision, as you've already pointed out. It's hindsight 2020 after the fact. Oh, I didn't like what happened, what came out of it. He got the better of me, so to speak. But that doesn't mean that it was unreasonable at the time. And the record reflects that she, speaking of trial counsel, on behalf of the defendant, on 3 specific occasions, provided her interpretation of it, which was counter to what the state was doing, and that's on pages 745 and 746 of the record on appeal. The strength of the recording is more than the words that you hear on it. If you watch the recording, and this is something that the defendant had to admit to when he testified, the recording reflects interactions between 2 people. Those interactions are Tavares Grimsley, also known as Baba, is letting the defendant, Mr. Wilson, have it. Because as the defendant had to admit to on his cross-examination, Grimsley was asking him why he let Diggum get shot and he accused him of letting Diggum get shot. So when you see that interaction, separate and apart from what it is you think you can and cannot hear, the damning part of the video is the interaction where Grimsley is letting Wilson have it because, in his words, he let their buddy get killed. And that's because they were participating in a robbery. When you talk about the co-defendant being acquitted, what's being overlooked is the co-defendant. That would be, once again, Mr. Grimsley, the one who's letting Mr. Wilson have it in the back of the car. He never got out of the car while this whole thing is going on. That was the problem in his case. The 2 people who participated in the robbery were Wilson and Eddie Peterson, who was Diggum, and Peterson was the one who got shot. Those are the ones who actually engaged the victim in the case, not Mr. Grimsley, who stayed in the Dodge Magnum. So those are important points to respond directly to what defense counsel is suggesting the court should consider. Frankly, the way the state looks at it is that defense counsel, notwithstanding what she says, and looking at it in hindsight and continuing to say that she didn't know the law, well, let me just suggest if she thinks that Wilson applies to this factual situation and you can't comment on the evidence because of Wilson, I'm going to respectfully suggest she still might not know the law if that's what she says. So it's the state's position that she cannot be ineffective for making what would have been a meritless objection, which is essentially what the trial court, I think, looked at. So the state argued below, we're arguing on appeal, that no witness in this case rendered an opinion. And that's what Wilson talks about. And that's not new law. That's not something that's some revelation about what witnesses can testify to. But that doesn't change what happens when the evidence is closed and we leave that room and we go into the closing argument room. A different set of principles apply, which is if something is introduced into evidence, I, as the counsel of record, making the closing argument, get to comment on it. And if there's an objection individually to what I'm saying, you make an objection to that. But the idea that, you know, this overbroad, well, you can't hear stuff. And first of all, once again, listening to the recording is not consistent with what is transcribed or not transcribed. That's a whole different thing. And experience would teach you that anyway. So the trial court got it right when it entered its written order saying, number one, that the trial counsel, Ms. Cashwell, she made a strategic decision. That was her choice. She got the benefit of it. She got to argue.
And what was the benefit, counsel? What was her benefit?
Her interpretation. I can read those to you if you like. I mean, it was her
I would like. I want to know your argument on how she benefited from agreeing, aside from the fact of whether or not it was proper argument, just in terms of prejudice.
Well, in looking at the record, as looks like bottom of the page, on page 745, in addition to telling the jury, you know, to listen to it, she says, I'm going to go through some of the in-car video. This is on page 744, actually, just real quickly, and then I'll come back to this. She says, number one, and there's three rules. Number one, you guys are the jury. Number two, you're the fact finders. Number three, it's your interpretation. And that's carrying over to page 745 of the record. Not the state attorney, not my interpretation, state attorney's interpretation. Says, I invite you to listen to it. And I think what you're going to hear when you listen to it is two men upset in tears. One of them, I think, is falling apart, and that's Grimsley. He's the one kicking the door and everything. And then she goes on, and I could continue to read. She's down at the bottom of page 745, or the record 745. She says, the second thing you're going to hear is Tavares Grimsley getting mad at Mr. Wilson and saying, you got out of the car. You got out of the car. She continued on page 746 of the record. And the third thing you'll hear is you'll hear Mr. Grimsley saying, why didn't you shoot him? Why didn't you shoot him? She goes on then to discuss each of those things. So she got the benefit of her interpretation in addition to telling the jury, hey, what we say is not evidence.
Is it your argument her interpretation is essentially trying to convince the jury that it was Grimsley at fault?
I think her interpretation is essentially that there's nothing to get out of it on behalf of against her client. I think is what, if I was to spin it. However, the court might want to note that what did come out during the closing argument, and this was transcribed, this was not interpretation. This is what the court reporter took down, and this is Wilson talking at this point in time. I grabbed that shit out the door, man. Diggum ran up. Diggum being Mr. Peterson, who got shot. He's talking about he grabbed the money out of the door. That's consistent with what the robbery victim said, which is he had money in the door and the money was taken out of the door. So setting aside all the debate about the quote unquote, you know, whether you could hear it, whether you couldn't, what they say, what they didn't say, what did come out of it is the defendant is reported as saying, I grabbed that shit out the door, man, then Diggum ran up. So he's confessing to a robbery. Back to where I was. And as the trial court correctly noted, Wilson applies when we are introducing evidence. It doesn't apply to a closing argument. You would be rewriting the law to do that. The trial judge, I should say the 3850 judge, went on to note that the jury was instructed that the attorney's argument was not evidence. In fact, both the prosecutor and defense counsel informed the jury on multiple occasions that their arguments and interpretations were not evidence. The jurors were invited to listen to the video. We don't know whether they did or whether they didn't, but if they had the opportunity to sit back in a jury room and listen to that and make a determination on their own what they were able to hear, not to mention observe the interaction between the two people, which the state suggests was the more condemning information, separate and apart from the transcribed portion of Mr. Wilson's basic confession. And there's nothing to suggest the jurors in this case disregarded those instructions. So in this posture, where this court finds itself is reviewing whether the trial court's findings are supported by competent substantial evidence. The state suggests yes, and that the law has been correctly applied, which is Wilson does not apply to the situation, notwithstanding the defense would like it to. Separate and apart from that, trial counsel made a strategic decision, and Wilson wouldn't have helped. Wilson wouldn't have got her where she wanted to go. So she made the decision. The evidence is in. I've got to deal with it. I'll put my spin on it. If the jury connects with me, connects with my client, connects with our position, my spin on it may carry the weight of the day. So for all of those reasons, and I want to address the other claims that have been raised since they were not addressed by appellate counsel, this court should affirm the trial court of 3850 court's decision. Thank you.
Thank you, Mr. Shippey. Mr. Ufferman.
May it please the court. Let me make two quick points in rebuttal. The first, I don't know what the law in Florida is regarding optical illusions, but I do know what the law is regarding inaudible recordings. And the law is a witness can't give an oral interpretation unless they meet the criteria under Wilson. No witness met that criteria in this case. So I really just think it's common sense. There's not a case on point. I'm asking this court to extend Wilson using common sense and say if a witness could not have done it during the trial, then why should a prosecutor be able to do it in closing argument? And again, I'd ask this court to address that and clarify that. I think for all the reasons I've given, the answer should be clear that a prosecutor can't. And if you ruled otherwise, then what that would mean is a prosecutor would never go out and get an expert and satisfy the Wilson criteria, because a prosecutor could simply get a partially inaudible recording introduced into evidence and then give his or her own interpretation during the closing argument. And that defeats the entire purpose of the holding in Wilson. So I submit the only way you can give any meaning to Wilson is that if a witness didn't testify to the interpretation. So yes, the tape's in evidence, but the interpretation was not. And therefore, a prosecutor shouldn't be able to give that interpretation when that interpretation was never admitted into evidence.
But Mr. Ufferman, the interpretation is not in evidence either. You would agree with that?
But the impact on this jury, I mean, the same reason that...
But that's true, correct? The interpretation is not in evidence.
In this case, the interpretation was presented to the jury through the prosecutor's closing argument.
But not in evidence.
There was no witness who testified to an interpretation because it was impermissible under Wilson. So therefore, a prosecutor in closing, the last thing the jury's hearing, shouldn't be able to get around what a witness could not have done during the trial.
But I thought, Mr. Ufferman, I thought though that's what the prosecutor can do in closing, give interpretation, inferences from the evidence. And why is that not what is being done here?
How can it be a fair interpretation if the trial judge himself in this case said, there's no way the court reporter can record it because I can't understand what's being said? Why would it be a fair comment on the evidence if no interpretation was actually given during the trial, because an interpretation could not be given during the trial? That again would defeat the entire purpose of Wilson. A prosecutor faced with that situation moving forward would never follow Wilson and would simply get the partially inaudible recording played for the jury and then give his or her interpretation during closing. And that gets around the entire purpose of why Wilson said a witness can't do it. Again, I think it's common sense. If a witness can't do it, why should a prosecutor be able to do it? And then briefly, this idea that she made strategic decision. I submit that a strategic decision can only be made by a defense attorney who knows all of the options and knows the law. And after weighing the options in the law, decides to pursue one path over another. If that's what occurred in this case, if she would have said during the hearing, I was aware that I could have objected to an oral interpretation, but I instead chose to give my own oral interpretation because I thought that gave me a better chance of winning, I would have no argument, clearly. But she didn't say that. She specifically said, I didn't know I could have objected. Had I known, there's no question, I would have objected, and and it is far worse to let the jury hear both of our interpretations because the prosecutors involves a confession than if they would have heard none. And for that reason, I ask this court to reverse and clarify what the law is regarding Wilson and closing arguments. Thank you.
Thank you. Thank you to both attorneys. The court now stands adjourned.